Good afternoon and evening to our guests joining us from Canada, and good morning to our panelists joining us here in Japan. My name is Leslie Ann Reed, and I am the Counselor Commercial and Senior Trade Commissioner at the Embassy of Canada to Japan, managing the team covering agri-food, life sciences, and innovation sectors. Au nom de l'ambassade, j'aimerais vous souhaiter la bienvenue à ce webinaire sur la protection de votre propriété intellectuelle au Japon et vous remercier pour votre présence. En tant que le pays le plus scolarisé de l'OCDE, le Canada regorge de gens innovateurs et entrepreneurs qui ont de grandes idées. Ces idées sont une propriété intellectuelle précieuse qui est à l'origine d'énormes opportunités de croissance, tant au Canada qu'à l'étranger. C'est pourquoi le gouvernement canadien a annoncé une stratégie sur la propriété intellectuelle comprenant 85 millions de dollars sur 5 ans pour aider les entreprises, les créateurs, les entrepreneurs, les innovateurs canadiens à comprendre, protéger et accéder à la propriété intellectuelle. Here within the Embassy's trade section, part of our mandate is to help Canadian businesses enter new markets and create partnerships with foreign companies, including by helping you protect and leverage your intellectual property. IP protection is important for your business, especially when expanding internationally. In fact, according to a survey conducted by Statistics Canada, more than half of businesses that own IP credit it with improving their success, with the most commonly cited benefit being the increased value that IP brings through creating a competitive advantage, enhanced reputation, and goodwill. However, the survey also revealed that the most common obstacles for businesses to file for IP protection outside of Canada are the complexity of the procedures and financial costs. As a result, it can be very important for companies to connect with IP specialized law firms to provide advice in that matter. So today, on behalf of the Embassy of Canada to Japan, I'm very pleased to welcome you to our first standalone webinar focusing on intellectual property. You will have the opportunity to hear from two leading law firms on how best to protect your IP in Japan, from Canadian law firm Gowling WLG and Japanese law firm Shiga International Patent Office. Following the presentations, we will have a question and answer session, and I encourage everyone to participate actively in this session and to take advantage of the expertise that we have in our panel. So we're really excited for today's event and offering the opportunity to ask questions. And I would just like to thank all of our presenters and our moderator today for their time and their expertise that they are sharing with us for today's webinar. For our webinar participants, I hope that you'll leave today's session with an enhanced understanding of how to protect your IP in Japan and feel better equipped to do so. Before I close my remarks, I'd like to highlight a few resources available to you, all of which we'll be sharing with you by email after the webinar. First, the Canadian Intellectual Property Office has a variety of resources on IP protection, from IP 101 to expert advice. The National Research Council of Canada Industrial Research Assistance Program, NRC IRAP, offers a program called IP Assist, which funds up to $30,000 to access IP professionals for certain IP-related services, including the development of your IP strategy. Export Development Canada has resources to help you protect your IP when expanding to other markets, and Canada's Business Development Bank has a $160 million envelope to support Canadian companies interested in IP-backed financing. Throughout all of this, we have Canadian law firms specialized in IP protection, such as Gowling WLG, who can assist you, and the Trade Commissioner Service can help you find vetted firms in other markets, such as Shiga International Patent Office here in Japan. In addition, our Trade Commissioner Network here in Japan and around the world is always happy to help you connect with Canadian companies. And if you have any questions regarding market opportunities in your specific sector of interest, please do follow up with my team after today's webinar. It is now my pleasure to introduce our first speakers, Mr. Tim Bailey and Ms. Sumiko Mori from Gowling WLG. Tim Bailey is the leader of Gowling's IP group in Calgary. Tim routinely assists Canadian SMEs with strategies for developing a global patent portfolio and also helps them to protect and leverage the value of their brands worldwide. He was recently ranked as a top IP strategist in Strategy 300 Global Leaders. Tim has his PhD in physiology, and he assists clients in various sectors and industries, including clean technology, oil and gas, biotechnology, and pharmaceuticals. Ms. Sumiko Mori is a partner in Gowling WLG's Ottawa office, focusing on patents and industrial designs. She works with a broad range of clients from small-sized businesses to innovative multinational companies. Prior to joining Gowling WLG, she worked at a leading Japanese law firm and practiced as a Japanese patent attorney before the Japan Patent Office. Thank you very much, and I'd like to turn it over now to our first speakers. Over to you, Tim and Sumiko.
Thanks very much, Leslie Ann. I'm going to start by sharing the slide deck with everyone. Please let me know if you can't see the slide deck or if there's any issues on the audio side. So here's the title slide for a presentation, Protecting Your Intellectual Property in Japan, a global law firm perspective. Leslie Ann did refer to us as a Canadian law firm, which is correct, but we also have offices around the world, and we'll discuss that towards the end of the presentation. In the spirit of reconciliation and recognition of our First Nations Aboriginal partners and friends, I'd like to start with an Indigenous land acknowledgement. I'm speaking to you from Calgary, Alberta, Canada. Calgary is located in the homelands of several Indigenous nations. Calgary is within the Treaty 7 territory home of the Siksika, Kainai, and Piikani nations of the Blackfoot Confederacy, as well as the Nakota and Tsuut'ina nations. The territory in which Calgary is built is also the home to the Métis Nation of Alberta, Region 3, within the historical Northwest Métis homeland. And Sumiko will be speaking to you from our Ottawa office. Ottawa is now built on unceded Algonquin territory. The peoples of the Algonquin and the Anishinaabe Nation have lived on this territory for millennia. So the agenda for our portion of the discussion is to briefly talk about what is IP and why is IP important for your business, some common challenges that we see as a global law firm, helping our clients go international or global with their commercial endeavors, which typically have an IP bent to them. And then we'll be hearing from our friends at Shiga International to give you some specific information on Japanese law firm perspectives on IP protection. So what is IP? I think it's an acronym a lot of us here, most of the people on the call probably are attending the call because you've heard this acronym a number of times. You know, from a very high level, IP can be characterized as an intangible asset embodied in a variety of different intellectual property rights. Those rights are derived from the collected knowledge, work product, and skill set of the people that make up your team. There are various different ways by which an entity or an individual can acquire intellectual property rights. One is through invention or creation, through directed purposeful innovation or branding strategy. The other would be through collaborating with others, either through some form of joint development or cross-license. And then there's also the acquisition of IP rights through purchase. In our view, IP is the currency of the innovation economy. It's one of the most valuable corporate assets that are out there. For example, sorry, my slide's shifting is not working exactly the way I want it to. So one of the most valuable corporate assets that are out there. IP, a knowledge and foresight and proactive approach to IP can facilitate the intelligent development of your products in your market by having a knowledge of the market, but also what your competitor IP may look like. So an example of this is the image I have in front of you here. So through our portion of the talk, we'll be referring a few times to a generic example of an autonomous vehicle. And so what I have here is what we call a hot map or a topographical map that represents a variety of different areas in which various entities are filing for patent applications with respect to autonomous vehicles. So the white areas would be, if you will, the white snow-capped top of the mountains, and the blue regions would be the lowest regions where there's the least amount of published patent applications. And you can see that there are various peaks, each representing a different sector or portion of the autonomous vehicle market. And so having this knowledge, you're able to drill down further into the data that's available and have a better appreciation for where competitors may or may not be filing patents with respect to one aspect of the autonomous vehicle industry. Another reason why we think IP is a valuable corporate asset is because it allows holders to use it as a lever to secure finance for company growth. So it's but one example within the autonomous vehicle industry was Aurora acquired Zoox for 1.2 billion US just a few years ago. And there's a litany of these examples of these types of deals that are happening. And the acquisition of the IP rights are what underlie the ability of the purchasing party to have some confidence that the rights that they're acquiring support the technology and the products they want to bring to market. And another reason why, and this is, I've just provided three, but there's certainly a long list of reasons why we see IP as being a valuable corporate asset is IP can be used to attract and solidify partnerships. And one of the, it's now kind of a dated example, but the Rockstar Consortium, which was originally Rockstar Bidco, was a consortium formed of Apple, BlackBerry, Ericsson, Microsoft, and Sony, whereby all of these parties came together and bought all of the patent assets of Nortel, a former Canadian technology success story. And they did this in a way to build up a portfolio in order to protect themselves and each other from a variety of potential IP risk. Another reason why IP is important, and here's some more empirical data that supports some of Leslie Ann's earlier comments. We know that for small to medium-sized enterprises in Canada, SMEs that hold a formal IP, meaning some form of IP registration or application for registration, are 60% more likely to be high growth, are 4 times more likely to export out of Canada. They're 3 times more likely to expand domestically and 4.3 times more likely to expand internationally. And I think these stats, this data supports the rationale for why a lot of people are attending the call with us today. So we think a critical step for, once we have a generic understanding of what intellectual property is and the rights, we think a critical step for parties that are looking to, secure the benefit of some of those previously mentioned advantages for having IP protection is to develop an IP strategy that's aligned with your business strategy, to contemplate what's happened in the past, what's happening now in front of you, and to contemplate what's happening in the future. So this is an important way to convert the intangible value of intellectual property rights into commercial value. Here's a quote from Jim Balsillie saying that too many Canadian startups and small or medium enterprises lack IP strategies. Even businesses that do rarely have viable strategies for using or enforcing their intellectual property rights. In Silicon Valley, patent protection strategies are present at all phases of R&D from the outset. I've never met Mr. Balsillie, but if I did, I would shake his hand and thank him for providing such a great quote for topics like this when we present them to members of the public. So the next critical step, once you've realized that, or hopefully beginning to convince you that forming a strategy, an IP strategy that aligns with your business strategy is important, you need to go through the steps of identifying what IP you may have through some form of internal audit. And in order to do so, very briefly go through the 5 categories of intellectual property rights. First one being patents, which protect inventions, which are new and unobvious uses of methods of, new and unobvious articles, compositions of matter, and processes. Patents provide a 20-year term typically, which allow you to enforce or prevent another party from practicing what your invention is as defined by your patent claim. Trademarks are a manner by which you can protect your brand, including domain names, including logos, slogans, and company names. Copyrights protect artistic works. I think that's becoming more and more important these days because software code falls within the definition of artistic works. And this is a region where I think I'm beginning to see in my practice much more focus is getting into copyright in terms of protecting software on the transactional side. And happy to answer questions about that if people have them. Industrial designs protect the aesthetic look and feel of produced goods or articles. In the US, these are called design patents, but effectively they're for the same protection of the same types of articles. And then the 5th category would be trade secrets. And these are the steps, procedures, mechanisms that party or an entity puts into place to help keep their secrets a secret, whether that be through contract, how they manage their internal workforce. So going back to our example of an autonomous vehicle, here you can see a Venn diagram where we've got the overlap between these 5 buckets or categories of intellectual property, where software would be available to protect, be protectable under copyright. Patents would be protecting the invention. So some form aspect of the car, the way it works, with the way it's its methods of operation. Trade secrets could protect, for example, some of the more nuanced architecture of the software platform. Industrial designs could be utilized to protect the design of the actual vehicle aspects, in the interior of the car, what it looks like, what it feels like, and then trademarks would be used to protect the logo and other aspects of the brand. In general, I think that a strong IP strategy is one that mirrors the IP assets that an entity has and the business plan that the entity has. If there's discord between the business plan and the IP strategy, then I think it's time to revisit the IP strategy to make sure that your business objectives are being supported by your IP strategy. Now I'll pass it over to Sumiko, who will discuss registrations.
Thank you, Tim. In this section, I will briefly talk about the timeline to register a patent. We will also look at global strategies to extend patent protection outside Canada and speed up the registration process. So let's look at the timeline for the patent registration. The graphic we are sharing you is a simplified registration process. This process has the following steps: drafting, filing, examination, and grant. The first step is drafting a patent application. In this step, the patent application is created to disclose the invention and define the scope of protection the applicant seeks. One point to keep in mind is that the patent application is a highly technical and legal document. If your patent application is not well drafted, it may make the examination process harder, and it may not be able to provide the scope of protection you want. The next step is filing. In this step, the patent application is filed with the patent office, such as Intellectual Property Office in Canada, and a required filing fee is paid to the patent office. In some countries, examination fees need to be paid. These official fees are country or region dependent. The next step is examination by the patent examiner. Once the examiner gets the application, the examiner reviews it for compliance with all requirements for a patent. The requirements include novelty, non-obviousness, and other stuff. Novelty means it was not available to the public previously. Non-obviousness means it is not obvious over those who practice in the field of the invention. The examiner conducts a search of existing technology in order to determine novelty and non-obviousness. If the examiner believes the application does not comply with the requirement, the examiner will provide an office action. The applicant will have an opportunity to reply to the office action. The applicant may need to negotiate with the examiner the scope of the claims defined in the application and amend the claim or claims in the application. The examination process may take 2 to 5 years or more. If the examiner examines the application and believes it complies with all requirements, congratulations, the examiner allows, and then a notice of allowance is issued. If you pay a final fee, then a patent is granted. A patent gives the owner up to 20 years an exclusive right to exclude others. there are no global patents. That means if you have a Canadian patent, it gives you the exclusivity in Canada only. So now let's look at the option to obtain the registration in Canada and outside Canada. For this discussion, we will assume you first file your application in Canada. There are several options to extend your protection in other countries. These options include Patent Cooperation Treaty, or PCT for short, Patent Prosecution Highway, or PPH for short, and Paris Convention. There are similar international treaties existed for trademarks and copyright. We don't talk during this session. The next slide shows example of the Patent Cooperation Treaty and PCT system. The Patent Cooperation Treaty is longer than the PCT application process, but let's talk about the Paris Convention first. That is the first one. The Paris Convention gives you 1 year from your initial filing in Canada to file application in other countries, such as Japan and the US. Under this system, your new application will enjoy the initial filing date in Canada. That is known as the right of priority. Next, two diagrams showing the PCT system. Under the PCT system, you will file a single PCT application in Canada. This application is an international application and will be treated as your initial filing in Canada and over 150 other members countries. One of the benefits of using PCT application is you will receive a search report and written opinion. ISR and WO on the slide refer to the search report and written opinion. They indicate if the PCT application meets novelty and non-obviousness. Another benefit of using the PCT is that you will have up to 2.5 years to decide if and where you want to obtain a patent. The PCT system does not grant a patent. If you choose a country, the timeline showing before the slide starts from the second step, filing. And there is also the strategy to combine the Paris Convention and PCT. The next slide shows the table. The table we are showing you provides some pros and cons of using the PCT system and the Paris Convention. As I mentioned to you, that if using the PCT system, you will receive opinion regarding a patentability, and also you will have additional time to decide if and where you seek protection. Having said that, PCT will be useful if you wanted to take the time to consider protection of your technology outside Canada. The next slide shows the Patent Prosecution Highway, PPH for short. The PPH is designed to share work products among multiple member countries or region countries. Under this system, if you file the Canadian application and it is allowed, you can request advanced examination in other countries by using the allowed Canadian work product. Alternatively, the PPH can be used in combination with the PCT system. As mentioned, the PCT system provides you with an opinion on potential patentability of the invention. Through the PPH, If your PCT application receives a favorable opinion, you can use it to request advanced examination in each country of filing. Considering the benefit of the PCT system, it will be efficient to use the PCT system and the PPH to get protection outside Canada quickly. Here, I focus on patent as they can be one of the most important assets to protect your technology. At the end of the presentation, we will provide a link to an online resource where you can explore the topics covered here and other things like trademarks. Now, I will hand over to Tim. Tim.
Thank you, Sumiko. So now I'm going to talk about the contractual aspects that relate to IP. So as a general definition, contracts are an agreement between two or more parties where the parties set out their mutual promises to each other, and it allows them the ability to allocate risk between them as they, for example, do business together. Contracts are relevant to this discussion because they can be used as a mechanism or a means by which to acquire IP rights. Contracts between a corporate entity and its employees or contractors often include very important terms with specific legal language in it that conveys the rights that an individual may have as an employee or contractor to the party that's paying their salary. It also allows the parties to identify who owes what to whom, and other forms of these contracts can be licensing agreements or purchase agreements, which I referred to earlier. Contracts can also be used to share IP rights between parties in an effort to spur collaboration. And so co-development agreements are one form of these agreements. There are joint development agreements. There are a variety of different titles for these agreements, but effectively it's the same idea of how two parties or more can make promises to each other, how much they will collaborate and allocate the risk that may arise under that collaboration. Franchise agreements are another example of how there can be a sharing of IP rights between parties. The other portion of our discussion that we wanted to talk about was to share some of our initial or high-level thoughts on the challenges that face Canadian companies when going global. With respect to global IP rights, there are a variety of complicating factors that may be present, depending on which country it is that you want to go into. So my comments below are provided as general comments, but each individual country that you may be considering entering into as part of your global strategy has to be identified and assessed on a piece-by-piece basis. So one example of a unique domestic IP law is in the United States, but for the United States Patent and Trademark Office, the applicant on a patent application has a duty to disclose to the patent examiner any prior art references, so publicly available documents that may be relevant to the patentability of their technology or the claims that they're using to describe their technology. Furthermore, I have as a second point, grace periods. Some countries provide no grace period, so that if there's a public disclosure of an invention prior to the filing of a patent application, then it's likely that any patent that is granted in that country could very well be invalidated if there was no grace period provided. However, in other countries like Canada and the United States, there's a 1-year grace period from a public disclosure in which a formal patent application has to be filed following one or more of the strategies that Sumiko just mentioned, in order to allow the inventors the ability to publicly disclose their invention, but still have the opportunity to try and secure patent rights for that technology. Other considerations that are important, and we also often talk to our clients about when they're considering going global, is having an understanding of where the invention, if we're talking about inventions, has been made. Some countries have what are called foreign filing license requirements. So it's easy to understand. I apologize. A good example is that in today's day and age where people are working remotely and there's less integration and incorporation of people's ideas in one given place, because we have Zoom meetings and what have you, there can be a portion of an invention that actually may be made outside of Canada. Some countries outside of Canada have what are called foreign filing license requirements. This means if you're collaborating on an innovation with someone who may be sitting in the US somewhere, you have to assess whether or not the United States Patent and Trademark Office's foreign filing license requirements are triggered, and whether or not you need to fulfill any obligations under those license requirements. Otherwise, a US issued patent may be invalidated for not meeting those foreign filing license requirements. Typically, these are in place to protect the development of innovations that relate to very sensitive types of innovations, technologies such as military applications and the like. The other issues that complicate going global relate to translation costs. Patent applications are technical documents and they can be quite large. And so translation costs are often something that has to be assessed before you assess or determine which countries it is you want to enter your patent applications into. And then there are other further jurisdictional specific requirements. For example, in some countries, if your patent application contemplates the use or incorporation of any natural resources, you have to make a statement in some jurisdictions that those natural resources are not protected in that country as they're contemplated for incorporation in your technology. Complicating factors with respect to contracts in particular relate to what we call in the legal world conflicts of laws. How does a court in one place assess a contract that was drafted elsewhere? So this is an important consideration for understanding when you're going through the process of drafting and negotiating an agreement, how do you want to address the implications of conflicts of laws? Furthermore, dispute resolution is a particular portion of a contract where it sets out the procedures by which parties will try to amicably, hopefully, resolve any dispute that may arise under the agreement. There can be a variety of different types of dispute resolution mechanisms. Those that explicitly dictate which will be the local law that applies to the interpretation of the agreement. Perhaps there'll be international arbitration rules that will apply, and also where the locations of the proceedings can occur. Again, these are things that you want to think of ahead of time proactively to consider, so that you're not agreeing to an agreement, you're signing on to an agreement where proceedings may be occurring in a different language in a different jurisdiction than where you're comfortable participating. And then, of course, across nations around our world, there's different languages. And so translation of key provisions in the contracts can be very important to ensure that the parties actually understand what it is that the other party considers relevant and important to the agreement. So to summarize, I think these challenges can be met proactively. The first thing to do is find the right market for your business, find out who to do business with and where. And once you're able to do that, and I think a lot of people on this call are certainly considering Japan as a great market, or they're already in Japan perhaps, you need to prepare your company and your technology. One way you can help prepare your company and your technology, in addition to what Leslie Ann referred to, the resources available on the SIPA website, is our firm has a website called GoExcel. It's effectively an online school where people can attend a variety of different courses and learn about the basics of branding, how to streamline the patent application process, whether to patent or keep it secret. And there's also a variety of courses on patent filing strategies. The URL is provided there if you'd like to attend and learn more about how you can proactively prepare yourself for things like taking your patent portfolio global. The other thing to consider about preparing your company has to do with ensuring that your company structure allows for international, addresses the potential international business through arranging your company appropriately, having the appropriate contracts in place. A common issue I see with my clients has to do with how they can move money or even their IP assets between companies that may be a company set up in Canada and a company set up abroad. There are oftentimes tax implications with simply transferring a license or assigning IP rights between companies that may be controlled by the same entity. Additionally, there may be foreign tax issues to address, and regulatory issues to address whether or not you can bring your product to a market in a particular jurisdiction, and what rules you have to meet to be able to do so. So we think that finding the right Canadian firm can help assist you with item number 2 above and getting set up or prepared for going global. Our firm, I think, is well suited for this. We have a number of offices in Canada. You can see on the right-hand side in red, and then we also have a number of offices in Europe, in the Middle East, and through Asia. And I personally have my practice. I work with many of these offices, helping our clients with their international global commercial needs, technology needs, and intellectual property needs. In our firm in the last few years, we've filed over 14,000 patent applications, with over 250 of them in Japan, over 22,000 trademark applications, and over 240 of those are in Japan as well. So again, I think we're well suited to help out if people have further questions or needs with the specific questions of IP, intellectual property, commercialization, and technology in Japan. And I think the last part that's important is finding the right partner in the places you want to go. And so this provides a segue for our friends at Shiga International Patent Office to take over the presentation and provide some more specific details on Japan and IP.
Thank you very much, Tim and Sumiko-san, for your informative presentations. Our next speakers are Mr. Tatsuhiko Abe and Dr. Hiroyuki Hashimoto from Shiga International Patent Office. Mr. Abe is a senior counsel at Shiga International Patent Office, and he has 25 years of experience in intellectual property practice. Dr. Hashimoto is a senior manager of Shiga. He specializes in mechanical and civil engineering, especially in general machinery, fluid machinery, heat exchangers, optical fibers, and control systems. He has a wide knowledge of Japanese patent practice as well as overseas patent practice, and regularly presents lectures on a wide range of IP topics at foreign IP organizations. I also want to again extend a special thank you to both of them, because they were both up early this morning to be able to log in at 6:30 a.m. here in Tokyo. So many thank you again for your enthusiastic participation so early in the morning. I will now pass the floor over to Mr. Abe and Dr. Hashimoto. Yoroshiku onegai itashimasu.
Thank you, Leslie-Ann, for introductions. Good morning from Tokyo, Heatwave Island. And the gathering friends already gave you an explanations about what IPs are. So please share the slide. Next. And the first topic is an overview of Japanese IP system and what are IP rights protected in Japan. So there are various ways to classify IPs, but this slide shows the rights to be registered at the Japan Patent Office, JPO. Patent, design, trademark, these rights should be registered at the JPO after filing and examined. There is also a utility model system in Japan, but it's not useful, unlike in Germany or in China. So I will skip about it. Next, please. On the other hand, the copyright, unfair competition prevention, geographical indication, these can also be protected in Japan, and these are not necessarily registered at the authority, although copyrights can optionally be registered. So the patent, trademark designs on which are registered at the JPO can easily enforce because you can easily prove the existence of the right. On the other hand, this copyright, unfair competition prevention, geographical indication, it can be protected, but may be difficult to prove the existence of the right. to be protected. Therefore, maybe sometimes difficult to enforce it. And then today's presentation webinar is mainly focused on patents. However, some audiences may be interested in global brand protection. And I will briefly explain about brand protection in Japan. And such brand protection can be mainly obtained by trademark law, unfair competition prevention law. And again, trademark should need to be registered at the JPO, and it's easy. Once it is registered, you can enforce it by claiming injunction or claiming damage based on such trademark rights. But if you don't have a trademark registered right in Japan, you need to prove that your indication, your mark is well-known or famous in Japan in order to enforce your unfair competition prevention. So it may be a little bit difficult. And the next slide shows how creation protection in Japan. I explained that patents, designs, trademarks can be registered at the JPO. Among them, the patents and designs are directed to creation. On the other hand, the trademark is regarded as selection in Japan, not creation, technically. Theoretically, but then technical ideas such as in the case of technical idea, you can protect it with a patent, and injunction or damage can be obtained based on the patent law. If you create a design, it can be protected by design, and again, you can enforce it based on the design law. And if a design is not covered by the design law, then you can again use unfair competition prevention law for limited terms and conditions. And the trade secret cannot be covered by the patent or design. It's difficult. However, it can be protected by unfair competition prevention law. However, in order to be admitted as trade secret, 3 requirements: confidentiality management, usefulness, non-publicity are required. It should be very careful about it. Then although various IP rights can be protected in Japan, but hereinafter this webinar mainly focuses on patents, and I will pass it to Dr. Hiroyuki Hashimoto next.
Thanks, Mr. Abe, and hello, this is Hiroyuki Hashimoto from Shiga International Patent Office in Japan. And this chapter 2, I'd like to talk about differences in registering IP in Japan compared to other jurisdictions, especially focusing on patent from the point of view of fastness, easiness, and subject of protection. And I'd like to start off from the fastness. This slide shows the schematic flow of obtaining patent. And as Ms. Sumiko Abgoling explained in the Canadian part, the general flow of obtaining patent containing 4 major parts as that is creation of invention, filing on patent application, and communication with patent office, and obtaining patent. And the general flow is almost same with Canada and Japan, but this communication with patent office is a little bit different or specific in Japan. Here in Japan, it is necessary to file a request for examination in order to start the substantive examination at the JPO. And during the examination procedure, you will have several times of receiving the obstruction from the examiner, and it's normally two times of obstruction will be obtained. First obstruction and final obstruction. And if the after responding to the final obstruction, you will receive the final results. It's mean the grant of patent or refusal of patent. In this slide, I'd like to talk about the timeline, how long will it take for two different timelines. One is the A, period from request for examination to first obstruction, and the term B, period from request for examination to decision of grant. And I would like to make comparison between major jurisdictions in this slide. In this slide, the period from A is listed in this column for Japan, US, EP, China, and Korea. And in this column shows the time period for B for Japan, US, EP, China, and Korea. And as you can see from this graph, for both time frame for A and B, I would say Japan is the most fastest country among those major countries. Next, I'd like to talk about the easiness. So second part of this perspective. Easiness means the I would like to focusing on the successful rate for examination. This slide shows a success rate in major jurisdictions for Japan, US, EP, China, and Korea. And this graph shows the success rate, means the it's a grant rate. And this graph shows the time trend for the success rate for each jurisdictions starting from 2015 to 2019. Now you can see it seems that China is going down a little bit, but for the other jurisdictions like US, Japan, Korea, AP, the success rate is growing or increasing year by year. It seems that the success rate in China is not so high, but I think it's due to the high rapid increase in the number of applications. So the success rate or examination is not in line with the increase of number of applications. So this might affect this number, but in general, the success rate in general is growing for major countries. And here I'd like to talk about a subject of protection. As Mr. Abe mentioned, that patent protect invention, and scope of invention and exceptions are mostly similar for all jurisdictions, but slightly vary in different jurisdictions, and especially comparing with Canada and JP, it's a little bit different for definition of invention. As you can see from this slide, the definition of invention in Canada is similar to that of in the US. But Japan the definition of invention is slightly different as described in this slide. And the you should be careful about the protectable invention, which can be covered by patent for in Canada and JP. So between Canada and JP, it's common that method of treating human is not patentable for both in Canada and Japan. But the you should be careful about the like method for diagnosing human and software program, method of treating animals other than humans, because those subject matter is treated in a different way in Canada and Japan, because in Canada, method for diagnosing human can be protected by invention, but it's not in Japan. But for the software program or method of treating animals other than humans, it's protectable in Japan, but it's not in Canada. So special care should be taken when the invention is related to software or medical practice. And here is the summary of this part, difference in the IP in Japan compared to other jurisdictions. Well, comparison of fastness is different depending on the jurisdiction, and it takes 1 to 3 years to obtain a patent on average. In comparison of easiness, success rate is different in each jurisdiction, and success rate change with time, and it's in pro-patent trend for major countries. And for comparison of subject or protection, special care should be taken when invention is related to software or medical practice, because it's treated in a different manner, especially between Canada and Japan. And here is the summary of the chapter 2, and I'd like to hand over to Mr. Abe for next chapter.
Hello, I intervene again for a couple of slides for the next chapter on what do Canadian companies need to pay attention to. And this slide is directed to us to attention to be paid when obtaining a patent right in Japan. It means protecting your own right in Japan. So it's actually nothing is difficult. Probably the audience is usually first filing in Canada or sometimes maybe in the US first. In such case, then through your local agent, definitely Gowling, then filing in Japan via PCT route or Paris Convention route, as Gowling friends explained a moment ago. Of course, you need to secure the patent eligibility and industrial applicability as explained in the previous chapter by Hiroyuki, but nothing is again difficult at all. Japan is a very pro-patent country and friendly to foreign applicants. However, there are especially two critical deadlines. You shouldn't miss them. One is Japanese national phase entry deadline. It's 30 months from the priority date. And another is a request for substantive examination. It is 3 years from the filing date. So in other words, 3 years from the international filing date as well. So JPO is currently quite stone-headed, stubborn, and to restore the lapsed right. So please pay special attention to keep these deadlines too. However, the next April, the law will be a little bit changed to ease the restoration. Next slide will be, on the other hand, regarding how to handle third parties' rights for Canadian companies. Attention to be paid in order not to infringe competitors' patents in Japan. Otherwise, even if you come up a great idea, great product, and you cannot sell, you cannot do business in Japan. So please carry out regular prior search by yourself or through another channel. And then once you own the registered Japanese patent right is found, which is quite relevant, then you should take proper steps in order to invalidate them, or sometimes license negotiations may be necessary. And if the third party right is not yet registered and still pending, then we recommend you to keep monitoring the status thereof. And once it is granted, then go to the second step and take necessary counter measures, please. Then this is a quick explanation of chapter 3. Back to Hiroyuki.
Thanks, Mr. Abe, and time is flying. And here is the final chapter of our presentation. And in this chapter, I'd like to talk about the IP enforcement in Japan, which might be interesting and very crucial for the company, a Canadian company who is considering filing their patent application in Japan. And this final chapter includes measure 3 plus first one is overview of enforcement of procedure. Second one is effective measures and talking about preliminary injunction. And last one is the arbitration or mediation process. And I'd like to start off from the overview of enforcement procedures. There are 4 steps when you find patent infringement. And first one is determine if the patent infringement really occurs. And second one is preparing and send a letter of warning to the potential infringer. Third one is having a negotiation with the potential infringer. And last one is the if the negotiation breaks down, then finally, lastly, the case should be brought to the court. It means the filing an infringement lawsuit. And this slide shows the explaining about the overview of determining if the patent infringement really occurs. And the scope of protection is clarified by Article 70 of Japanese patent law. It means the scope of protection is clarified based on the claim. What is described in claim of the application? But beware of Article 104(3). This means the restriction on exercise of right by the patentee. This kind of exception is existing, so there should be taken this kind of exception. But basically, the scope is determined by the scope of what is described in claims. And second step is to identify the product's method in concern. For method claim, sometimes the applicant thinks that it's very difficult to specify what is carried out at the potential infringer. But there are requirement of 104(2). It's mean the obligation to clarify specific circumstances of it. very similar to a duty of disclosure in the US or Canada. And also, doctrine of equivalence can be applied for identifying the product or method. And finally, making analysis if the product's method is included in the scope of protection. And next step is to prepare and send a letter warning to potential infringer. And paying attention to the contents of the letter is the patent line should be clarified by patent number and describe claims of the patent. And important point is that it is not recommended to include emotional message, threat, or inquisitions. So this kind of message have a negative impact when the case is brought to the lawsuit. And determining to whom the letter of warning to be sent. And potential infringer is the recommended target to send the letter, but care should be taken that letter should not be sent to client of the potential infringer. And there would be a risk to violate the Unfair Competition Prevention Act, and it's coming from the case law from Japan. So the person to whom the letter will be sent should be very carefully selected. And next step is the negotiation with the potential infringer, and it means the case should be subject to mediation or arbitration, but I'll discuss in the other section. And finally, if the negotiation breaks down and the case would be brought to the court, and patent infringement lawsuit in Japan is handled by Tokyo District Court or Osaka District Court. And here is the rough outcome from the lawsuit of the patent infringement lawsuit in Japan. And this part shows the case from court. It means the judgment. And this part shows the results coming from settlement. It's the negotiation. So from this graph, you can see the acknowledged case is not so high, but taking this part into consideration in which the settlement is successful. So the overall successful rate is not so low in Japan. So I would say the patent right is enforceable enough in Japan. The next part shows the effective measure of preliminary injunction. And this is a very special technique to enforce your patent right, because in general, the patent infringement lawsuit takes very long time, and it's compared to the general civil action, it's much longer for patent infringement lawsuit. But sometimes patent right must be protected much faster. Then preliminary injunction could be one option to achieve fast protection of patent right. If you use the preliminary injunction, you can receive the results very fast compared with the infringement lawsuit, because normally it takes more than 1 year for infringement lawsuit. But if you use the preliminary injunction, you can receive the results less than a year, about a month. In preliminary injunction, if you win the first trial, you can enforce the judgment immediately. So it's very effective and fast. And difference between preliminary injunction and infringement lawsuits are, in the case of infringement injunction, if there's a petition from the infringement side, then patent owner must file an infringement action along with it. In preliminary injunction, witness interrogation cannot be performed. In preliminary injunction, it is easy to keep the murders being raised and confidential. And in the preliminary injunction, the doctrine of equivalence cannot be claimed. So, and the case where temporary deposition is used when you want to enforce a judgment promptly, when you want to keep a case confidential, and in the case of preliminary injunction, in order to expert pressure on the defendant after an infringement discharge in the plaintiff's favor in an infringement lawsuit. So filing the preliminary injunction for the purpose of an advantageous settlement. So this is one option to enforce your patent right in Japan. And I'd like to quickly go through the brief idea about the arbitration mediation process in Japan. As an alternative to litigation, the parties may agree to settle their dispute through alternative dispute resolution. It means ADR, such as mediation or arbitration. ADR includes the two types of procedure. One is adjustment type, including mediation and conciliation. Another one is determination type, including arbitration and determination. These are the advantages of ADR: non-disclosivity, flexibility, expertise, promptness, and internationalities. And possible reason why the number of litigation in Japan is so low is that high cost, amount of damage compensation is not sufficient, high likelihood to lose lawsuit, and not fully enforceable in litigation. Because Japanese national characteristics, parties, and interests tend to avoid disputing in court. So ADR has high affinity for interested Japanese party, let's say the companies. And here is the specifics of the arbitration mediation process actually works, but there are three types of ADR: civil type, justice type, and administrative type. But I'd like to skip this slide due to the time limitation, and I'd like to go on to the last slide for tips for SMEs, Canadian SMEs. Negotiation would be your first choice when you consider enforcing patent right in Japan. And if the negotiation does not go smooth, ADR can be used to facilitate the negotiation. And preliminary injunction can be utilized for conducting negotiation. And here is the all of our part. And thank you for your attention. And I'd like to hand it over to the facilitator, and I would like to answer your question if you have. Thank you very much.
Thank you very much, Abe-san and Hashimoto-san, for that very informative and comprehensive presentation. I would now like to introduce the moderator for today's question and answer session, Ms. Catherine Simchuk. She is the Senior Business Development Manager for Gowling WLG's Global Intellectual Property Group. Catherine supports the harmonized strategy of their 13 offices across Canada, UK, Europe, Asia, and the Middle East. Prior to her move to the business side of the law, she was a practicing trademark lawyer herself in Gowling WLG's Ottawa, Toronto, and Moscow offices. Catherine, over to you.
Thanks so much, Leslie Ann. And this takes us to my favorite part of webinars, offering free legal advice. So I hope that all of you have a lot of questions. I see in the Q&A, some of you have already typed in some questions, and I will read those aloud and ask some of our panelists to answer them. But I do encourage you as well to take advantage of the raise hand function on the bottom of your screen. That will enable me to call upon you, and you can unmute yourself and even allow us to see you and ask your own question live. So if anybody would like to do that, we will keep an eye on the attendee list. But in the meantime, I'm going to start off with the first question in our Q&A, which was from Mark Romanesh. He wondered whether their grace periods in Japan as they relate to prior disclosures by inventors. He wonders if we could speak a little bit about that. Perhaps you, Dr. Hashimoto, could answer that question.
Thank you, Catherine, and I would like to answer this question. And actually, there is the grace period system in Japan, but it's a little bit different from that is existing in the US, Canada. So here in Japan, we have a grace period system. It means if the invention is disclosed by the action of the inventor itself, you can file the invention within 1 year after the date of invention. And generally, JPO is adopting the absolute novelty system. So once the invention is disclosed, in the end, the novelty is destroyed. But if the novelty destroyed action is made by inventor itself, then JPO will applying the exceptional for the this kind of action. Then you can have 1 year time period from the date of disclosure to filing the patent application. Then you can use this kind of grace period in Japan. I hope this answered the question.
Yes, I hope, Mark, that answers your question. If not, please feel free to raise your hand and ask a follow-up question. But in the meantime, we had a couple of questions from Mark Vanderbeeken. And I see, Tim, that you answered answered that question in the Q&A. Did you want to just make some follow-up comments to that?
Yeah, I think so. So the question was why file in Canada first rather than file at the USPTO, taking advantage of what's called a provisional patent application. As I tried to articulate, at least in my typed answer, we certainly do file a lot of provisional patent applications on behalf of our clients. I think it's always a fact-specific scenario that determines whether you want to file a US provisional first or whether you want to file another formal application first as your first filing. Scenarios where a provisional application is applicable are certainly when perhaps someone is about to go into a public disclosure scenario they can't avoid. For example, they're about to make a pitch to investors and the investors are won't agree to sign a non-disclosure agreement, or perhaps they're going to participate at a conference. I've even had someone approach me for some advice the day before they went on a TV show that I won't name here. It rhymes with Braggins Bren, and it's a show where people go and pitch to potential investors. And so I gave them some advice as to how to try and mitigate or reduce what they actually disclosed during the taping of that show. So those are scenarios where filing a provisional makes sense. Because you're trying to secure your first filing date as soon as possible. However, there are other scenarios where filing a formal application, for example, in the US or maybe Canada or the PCT makes sense as well. For example, if the client's eager because they're aware of a potential competitor, they want to get enforceable rights as soon as possible.
Thanks, Tim. And there's another question while I have you in the spotlight. There's another question that's very near and dear to my heart, having practiced trademark law myself. And that is, and Tim, I'll ask you the first part of this question, whether you find with your clients, because I know that you practice trademark law as well, that having a trademark registered in Canada and the US, are there any advantages or benefits when they go to register elsewhere? And then I'll ask about in Japan in particular.
Well, similar to in patents, how you can have an earlier filing provide a benefit to later filed applications. The same thing can happen if you have an earlier filed application in Canada or the US. Then within a certain time frame, you can file in another jurisdiction and claim priority back or the benefit of that earlier filing in Canada. So what that means is that if you file in Canada on July 1st, 2020, and then you're seeking to file in another jurisdiction after that date, if you file within the prescribed amount of time, let's say it's 6 months, then the examiner in that subsequent country, so if they file in the US second, they won't be able to raise anything that may have been publicly available on the trademark database against your originally filed application, because you can rely on the earlier filed Canadian application. And I think my colleagues and friends in Shiga would be able to answer the specific Japan question.
Regarding this question, it doesn't really, there is not a real advantage even if you have a registered trademark right in Canada or in the United States. During the trademark examination in Japan. However, if your trademark is well known in Canada or in the United States, such fact may prevent other parties' similar application, trademark application in Japan to be rejected. So that may be a benefit, one benefit. So may not be a satisfactory answer, but this is my comment.
And Mr. Abe, the follow-up question to that was, how long does it take to register your trademark in Japan, approximately?
Yeah, depending on the situation, if it goes quick, smoothly, definitely less than 6 months. However, if there is a similar application, conflicting third parties application, then it will take longer. However, the trademark prosecutions in Japan are quite quick now.
Wow, correct me if I'm wrong, Tim, but that's a lot faster than in Canada at the moment. Moving on to the next question from Paul Chang, and I think this will be for our friends at the embassy. Paul Chang wondered whether he's just talking about how the legal expenses are getting very expensive. I guess he's filed in a number of countries, and he's wondering whether the government will help with filing fees and also how to make contact with Japanese steel manufacturers.
Yeah, I'm happy to take that question. So in my opening remarks, I mentioned that there are some government programs to assist Canadian companies with IP. One of them that I mentioned is the NRC IRAP IP Assist program, which allows up to $30,000 in funding. And the key points to know about this particular funding is it's $10,000 to define an IP strategy, $20,000 to assist with implementation. However, it does not include costs for drafting and prosecution of patents or patent office costs or filing fees or legal opinions. So there are a number of elements that it does include, though, including an IP audit, competitive analysis, background art search to determine freedom to operate. So there are aspects of that program which might be able to assist with reducing some of the costs related to properly protecting your IP internationally. The key here is that it would be important to contact your IRAP advisor if you have one, and if you do not have one, we have a phone number to help you get one, and that information will all be shared after the webinar. We'll be sending it out to all participants. In terms of connecting with Japanese steel manufacturers, that's something that our office, the Trade Commissioner Service, we're happy to assist with, and we'll have the officer responsible for that sector get in touch with you directly to learn more about the type of company you're interested in connecting with. So we'll follow up with you by email after the event, and that offer goes for any of the companies on the line. If you're interested in meeting with Japanese business partners, please do contact us and we will connect you with the right sector officer.
Wonderful. Thank you, Leslie Ann. I think following up on the first part of your answer, perhaps it's a good time to ask one of the questions that came into us in advance of this webinar, and that was, what is the cost estimate to process a patent in Japan, including legal and patent office fees?
It means the total cost for or. So I'd like to clarify then.
It's the cost estimate to process a patent in Japan, I guess to prosecute it through to registration.
It's very difficult
Very
to answer
difficult.
because it's very depending on how many times you will receive the office actions. But normally maybe about approximately it's roughly bits because it's really
We're not going to hold
yeah,
you to it.
1 million Japanese yen would be in total until the grant would be the rough estimate.
Currently, Canadian dollars, US dollars are quite strong against Japanese yen, so it's the right time to file an application.
There you go. Unfortunately, I don't have a conversion calculator in front of me, but sounds like it's about 1 million.
Actually, one comment regarding this point, because it's really depending on the process, how your process are responding to the office action. So normally, we will prepare our comments or analysis to the applicant, what is written in office action, and we'll make a proposal to overcome the office action. This costs much about fees because we are using time and make analysis. But if the analysis is made by the applicant, you can reduce the amount of fees. So it's one option. So please, for specific amount, please feel free to consult us. So we are always happy to provide you the quotation for each case.
Thank you, Dr. Hashimoto.
In terms of the conversion, sorry to jump in, it's roughly about 10,000 Canadian right now. 1 million Japanese yen.
Thank you. Thank you.
Really? That much?
Yeah, that sounds about right. And following up on that question about costs, there was a question from Jane Ritchie, and she asks, does the JPO offer government fee reductions for small entities? And what constitutes a small entity patent applicant in Japan?
Yes, they do. However, now I don't have a detailed data here, so we can answer to on this question later on in more detail.
Great. And to everybody, we will be providing the email addresses and phone numbers of all of our panelists. So, and these presentations will be available to you too. I believe that will be sent with that email Leslie Ann is referring to. So we do encourage you to follow up by email.
Yeah, but definitely the SMEs can enjoy the fee government fee reduction in certain under certain terms and conditions.
Great. And we have another question here about actually custom clearance. It's about that it can be, there's a question and answer period during the custom clearance procedure in some jurisdictions, I guess. And Mary Teko is wondering if it's challenging custom clearance for Japan and how that would work with language barriers.
I would say it's a lot of effective for custom clearance, but it's really different for trademark and patent. For trademark side, it's very easy, or design is easy because the staff or customs can easily find the product, but for the patent side, it's not sometimes difficult. So, but in general, it's effective, and we are always using this services, and we are obtaining the satisfactory results.
Right.
In Japan, yeah.
Okay, thank you. And another question we had in advance of today's webinar, I know, was whether you can reduce the cost, the translation cost that Tim spoke about by using AI software when you are filing in other non-English speaking countries. Sumiko, did you want to address that question?
Yes. So now AI software has been developed and improved and very getting better. But from my point of view, still it's not accurate. And also this is what I said is that a very technical and legal document. So we are very careful to take care of those documents. That means if you're going to Japan and you want to do something in Japan and create document, or you want to create document based on English, I think I recommend using the professional like Shiga, because they can proofread actually. And also there's a very possible risk to reduce your what you can have, what you are entitled.
The scope of your protection. Exactly. That's great. Well, I'm just realizing that we've come to the end of our Q&A that went by very quickly. And as we mentioned, that we do have the email addresses and phone numbers of our panelists that Tim will show on the screen right now. And we invite, they've graciously agreed to answer any questions, or if you want to chat with them further, here are their contact details. So we hope that you'll get in touch. And of course, it would be our friends at Shiga to answer any of your questions about IP in Japan. And for those of you who may have questions about IP in Canada or going global with your IP, then definitely Tim Bailey and Sumiko can help you with that. As Tim mentioned, we do have offices, a number of offices internationally. So our IP team across the globe can really help when it comes time to go global. And we're also a full service firm. So if your needs go beyond intellectual property, we can find someone that could be your trusted advisor in that area as well. So please feel free to get in touch with me if your needs go beyond IP and Canada. Thank you very much.
All right. Thank you very much, Catherine, for this great Q&A. We're very fortunate to have had you moderate it. Bonsoir à tous. Good evening, good afternoon. My name is Audrey Jolin-Lessard. I'm a trade commissioner at the Embassy of Canada to Japan, and I'm also the manager overseeing intellectual property. I'll be very brief, please fear not. I hope you got as much out of this webinar as I did. I think Tim started it very well by summarizing it with this beautiful sentence along the lines of the fact that IP is the currency of the new innovation economy, and that when you protect your IP, you can use it as leverage to both grow your company and also attract and solidify some partnerships. So in a nutshell, IP rights in your business may overlap. And when it comes to filing a patent in Canada, the process can take 2 years or more, but then it's valid for 20 years. And in Japan, I personally was very pleasantly surprised to learn that the process can take as little as 6 months to file for a patent. However, we have to be careful because definitions in Japan, such as the definition of an invention, is different. So please, by all means, do not hesitate to contact our speakers to seek some professional advice if you need to, if you need some assistance, for example, to navigate the processes of the Japan Patent Office. Unfortunately, we were not able to answer all the questions. Thank you for your great and active participation. But don't worry, we did write down the name of people who raised their hands or asked questions, and we didn't have time to answer. So we'll be following up by email with you. My team member, Ryoko Uchida, who is our intellectual property officer, will be sending you an email with, again, the coordinates of
our guest speakers in case you didn't have time to do a print screen earlier. And we'll also send you the list of programs offered by the Canadian federal government to help you develop an IP strategy and protect your IP more generally. So one last time, I would like to invite you to join me into thanking our guest speakers for their very insightful presentations. So today you heard from Shiga International Patent Office, from Mr. Tatsuhiko Abe, as well as Dr. Hiroyuki Hashimoto. And from Galling WLG, we had Tim Bailey and Sumiko Mori, as well as our great moderator, Catherine Simchak. Thank you again to all our speakers. Thank you also to our participants for the time you devoted to this webinar. S'il vous plaît, n'hésitez pas à nous contacter, c'est-à-dire le service des délégués commerciaux du Canada au Japon, si vous avez des questions sur le webinaire d'aujourd'hui ou encore sur les opportunités pour votre entreprise dans le marché japonais. Ça va nous faire plaisir de répondre à vos questions et de discuter avec vous. Et bien sûr, vous pouvez nous contacter dans la langue officielle de votre choix. So lastly, when you disconnect from this webinar, there will be a 5-question survey that will pop up. It only takes a minute. If you could fill it, that would be very helpful to us because this is a way we improve and we can offer better events to you every time. The first 5 questions are in English and then questions 6 to 10 are the same, but in French. So thank you again very much to all of you. Merci beaucoup. Nous vous souhaitons une excellente soirée. Have a good evening.